Aloha, this is Professor Porter. This is part 5 of a 10-part series of the Introduction to Mock Trial. This particular part, understanding theme and theory, might be among the most important that we'll cover in the whole introduction course. As always, follow on the YouTube channel and submit any requests that you have for me by Gmail. Could be future video requests, could be specific questions or comments. So the start to everything having to do with theme and theory. I think theme and theory is one of those concepts that when you're in mock trial or when you're reading a book about trial advocacy, they get thrown around a lot. They're confused. They're used interchangeably. So I want to try to unpack theme and theory and understanding theme and theory. And I purposely think this first thing right here, how you analyze your case, how you segregate your case, how you start to pull apart your case, comes before figuring out theme and certainly figuring out theory and why you win. So what I wanted to think about is, how do I analyze a case first? I think we think about it like it's a magazine article, like you're reading a chapter of a textbook. I'm going to read a case file. And there's plenty of people that can read a case file and say, oh, okay, I know what we're going to do. All right, here's going to be our theory. Here's how we're going to win. Or I have an idea as to how we can explain this to jurors, explain this to an audience new to this case, and what will be our theme. But for the rest of us, for most of us, you'll read it once, you'll read it twice, you'll kind of pour through it a couple times. And after you start to get a feel for who are the characters, what's the basic fact pattern of what's going on, what's the person that brought the case, if it's a criminal case, the prosecution, the plaintiff, or in a civil case, that plaintiff that filed a complaint, what are they alleging? What's sort of the cause of action? What are they saying went wrong here, and what's the relief they seek? You start to analyze what this case is about, and you start to get your arms around what this case is about. And then I would suggest that you're starting to do some basic segregating of information, segregating of material, and start to organize and place material in different buckets. Now, it doesn't really matter at this stage. I use kind of the picture of the garage storage unit because it doesn't need to be pretty. It doesn't need to be color-coded and tabbed. It doesn't need to be sort of organized in expandable folders, old school wise, or with lots of virtual folders on your computer. Very crudely, almost in an index card pitching sideways type of way, trying to think, all right, let's break down testimony from a witness that's included in the mock trial packet, testimony from a witness that I expect to be part of the trial in this case. That witness is going to say a bunch of things. They're going to say some stuff that's on the outside that's extra, that's not really important, that doesn't move the ball one way or the other. But they're going to say some things that are good for you, good for the home team. Hopefully there's a reason, if they're your witness, there's a reason you're calling them. So they're going to say some things that are good for you. Then they're going to say some things that cut against you. While that's true, that's not all that good for the home team. And I think starting to organize bits of trial testimony, facts that will come, or that we expect to come out of the witness's mouth at trial, start to organize them. Which ones are good for us? Which ones are bad? Maybe there's even a third pile. I think when all of us that have gone through trials have sort of said, we're not sure about this one. I get an argument as to it. I think I can work with it, but I also see that it's a fact that could cut against me. So maybe there's a third pile in the middle, and you just start to separate. Then you got some exhibits. There's this exhibit that I expect to be part of the trial, and that gets more obvious and easier to identify in mock trial because it's a closed packet. They've included an exhibit. They've included this performance report from someone's employer. Okay, well, from my perspective, is this a good thing for me or a bad thing for me? Or as part of this performance evaluation, good for the home team, or is it not good for the home team? Really starting to separate out almost every bullet of trial testimony that's relevant, that's not extra, and every exhibit that you expect that could be part of the trial or that someone might try to admit at trial, looking at it wholesale and looking at the parts of it to say, is that going to be good? Is that going to be bad? And really starting to pull apart, what's the part that I'm going to hit to say, here's all the good stuff at this trial? And what's the stuff that I expect that if I'm going up against a competent opponent, you should always expect that. If someone is doing the same drill, but doing it on the flip side of this case, I represent the plaintiff, they represent the defense, or I represent the defense and they represent the plaintiff or the prosecution in a criminal case. If they're doing this same pulling apart, if they're doing this same crude index card type organization, what are they going to do with all that the stuff that's bad for me, that's good for them? How are they going to present it at trial? How are they going to craft arguments from it? So if you start at this very foundational building block, good facts and bad facts, and segregating out good facts and bad facts, then I think before you even get to what is this case about, how are we going to win, what's our legal theory, what are the types of themes we can use to explain it to our listeners, to our jurors who are hearing this for the first time, you can really back up a step and just say, good for me, bad for me. And if you keep track of it, doesn't mean you might change your answers and you can move one over from one pile to another later on. But after you've taken a couple of reads, after you've familiarized yourself with the characters and the facts of the case, starting to pull the case about, you can say, here's how I have to focus. Here's how I have to think. How I streamline my presentation and how I'm prepared for what I expect the presentation to be on the other side. So now we're going to introduce these two popular words in trial advocacy. You can pick up any book on trial advocacy. You can go to any trial advocacy course. There's got to be a class. There's got to be a session. There's got to be a lecture. There's going to be a chapter, something explaining these concepts, theory and theme. And what I want you to think about, I'm not sure they're the best defined words that we have in our skills courses and in our teachings. A case theory is just how are you going to prevail? This is a competitive adversarial process trial, and mock trial is no different. If you represent the plaintiff and it's a car crash and you're saying it's the defendant's fault who drove the white van who worked for some company, well, you're going to have a case theory as to how, why, have they done something wrong, the basis of our complaint, by which we can get relief, by which we can get damages, often money. What is our theory for why we win? That's about as simple as you can make it. So in a lot of cases, mock trial, again, it makes it somewhat easier. If it's a criminal case and you represent the prosecution, your theory is usually going to be they have committed this crime with these elements that's set out in your packet. If it's a murder case, there's going to be elements of murder that are described in jury instructions or in some other form in your packet. And your theory has to be this person who's on trial here, the defendant is on trial, did this, and we can prove beyond a reasonable doubt, the standard of proof in a criminal case, that they've committed this crime with these elements. That's kind of almost every prosecutor's theory. There's some intricacies to it. There's some nuance to it, but that's their theory. Defense, especially in a criminal case, especially in mock trial, a lot of times it comes down to, yes, someone did this thing. Someone committed this murder or had this robbery or distributed narcotics or whatever it was, but it wasn't this defendant. So it's like an identity defense. So their theory is essentially, you can't prove, prosecution, that this person is the proper defendant here. You can't prove. My theory is this guy didn't do it or someone else did it. So when you think about theory, it's simply what is a guiding principle as to how you will prevail at trial, how you will be successful at trial. Now, you don't often get a verdict in mock trial. That's the one thing that, especially the younger the competitor, if you're in high school or middle school or if you're in college, they want to know who won the trial. Well, mock trial is a contrived facts on each side. It's for the point of the advocacy, but you still have to be advocating at every stage. Opening statement, direct examinations of your witnesses, cross-examinations of their witnesses, arguments through the court, closing arguments in summation. Everything you do is in the direction of prevailing in this mock environment. You want to win this case and you want to adhere to a theory that can allow you to win this case.